Yo guys, welcome to Trend Ram. My name is Vieko and today I'm going to be talking about the law. So I'm going to be talking about European Union law on artificial intelligence. So recently I decided to kind of download all the EU laws for AI, and I just wanted to see where the European Union is, with the whole AI thing. Is there some things that we must be aware of? And yeah, we have a lot of things to be aware of, to be honest. By the way, before I go full deep into the topic, I just want to say I recently also released a video on my Patreon on topic of AI, where I'm generally explaining all the techniques that I'm currently using, how I'm developing my workflow with AI, how I'm making everything super fast. So if you're interested in that, head over to the Patreon and you can find some cool things there. Let's continue with the EU and the law. So the website that I use to download all the AI stuff or all the laws for AI is this one. It's EUR Lex. So here you can find all the laws regarding European Union. And since, reading the law is for professionals like lawyers, which I'm not a lawyer, so don't take my advice for any of this stuff that I'm saying here. So since reading the law is actually very tricky, I loaded all the laws that I downloaded from EUR Lex. So I loaded all the laws here in Notebook LM, and I generally use Notebook LM to kind of assist me to understand the law. For those of you who don't know what Notebook LM is AI. It's a Google's chatbot, but the only difference is Notebook LM doesn't know anything. So whatever documentation you put in Notebook LM, that's the only knowledge that it will know. So for example, if I ask Notebook LM, based off all these EU regulation PDFs, if I ask it, how to bake a strawberry cake in the oven, he will not know because it doesn't say in the documentation. One other thing is, whichever thing he writes, for example, as you can see, there are like these numbers. Whatever he writes, if you click on one of these numbers, he will directly tell you which PDF or which part of the law explains, this whole thing. Now, let's start. A lot of the laws are going to be rolled out on August 2nd of 2026. Some are going to, transfer to 2027, but the major ones that I'm going to be talking about are going to be rolled out mid this year, so 2026. And one of the major things that's coming is that AI-generated images, videos, sounds, whatever, are going to have to be labeled as AI. This applies to business individuals, so people who can invoice, their work. For so-called natural people or natural persons or people who just, create AI stuff for their kind of enjoyment, you don't have to label anything. But now here is the catch. Labeling AI work, it has levels. If you are doing any project for the client, and if the images, let's say, that you deliver, if the majority of the image is altered with AI, you must label it as AI. So whether you're going to write on the image that it's just AI or AI generated, it's up to you, but apparently it must be super clear that you label it as AI. But now there is a point where you can use AI on the images, but you don't need to label it. And that's pretty much if the majority of the artist creativity that you see in the image is your own and is not altered by AI. So for example, if you want to just enhance how the leaves on the trees look like in the back, so that the trees look more photorealistic, you do not need to put an AI label on it. But if you go and generate the entire forest in the back, without your creative direction, where you pretty much just prompted out, make me a forest, then you need to label it as AI. So here, if I go into this document, I think that's kind of the biggest document for AI rules regarding European Union. And if I go to this section 133 here, look what it says here. So this whole section pretty much tells you that, how you need to label things, etc., etc. But then in the end, it says to remain proportionate, blah, blah, blah. Marking obligation should not cover AI systems performing primarily as an, Jesus, what is this? As an assistive function for standard editing or AI systems, not substantially altering the input data provided by the deployer or the semantics thereof. Meaning, assistive function is you're in charge of everything, just, a bit here and there, etc. You're just enhancing it. That's not a problem. So you don't have to label it as AI. But now you must be thinking, you created, this fancy image of this building or whatever. Is your client going to be happy that you must, write AI generated on it, etc., etc.? Well, there is a way to go kind of about it. So there is this thing. If I go down to section 134, it pretty much says, you have to label stuff, blah, blah, blah. But this section pretty much respects the art part, where the content is a part of an evidently creative, satirical, or artistic, fictional kind of work. In those cases, the transparency obligation for deep fakes, meaning AI modifications, set out in this regulation is limited to disclosure of existence of such generated or manipulated content in an appropriate manner. And now get this, that does not hamper the display or enjoyment of the work, meaning that if you value your work to be an art, you don't need to put that it's AI generated directly on the image, but somewhere around it, it has to be mentioned. So that's kind of the thing, because that's that does not hamper the display or enjoyment of the work, because, you're essentially making the image more ugly if you add AI generated, but it's less ugly if you put AI generated on the side, I guess. So as I started generally reading this whole thing, like researching this whole thing of EU laws and how it treats this and that, of course I had millions of questions, right? Do I need to mark a work as AI if I used AI scripts? Like if I wrote a bunch of scripts for Macs in AI or like with AI, is my final output a subject of, labeling it as AI? And the law pretty much says no, because the only thing that matters here is the output, meaning what the other viewer is looking at. How I got to there is pretty much not a problem. So if my render is, full on CGI, but I used AI for example, scripts that made me faster, that's pretty much assistance. That's like assistive AI thing. But on the other hand, if I created a script or a plugin that generated the design of the whole render, right? If it generated like the whole environment and all that, and I literally just prompted, create me a city, then that is like, even if you just render it out and it doesn't have any AI post-production, it is AI generated, because the decision of the creative process is done by AI. One of the first questions that I generally thought of is, regarding the labeling, a work to be AI is, so I'm a company and I make a product for someone, right? And I guess I have to deliver it and, have it marked as AI. But what if I am, a company that does a work for another company, and that other company will, delegate the work to the public, to the general public? So, like, is it my responsibility to label it as, as AI, or is it their responsibility to label it as AI? Because in this case, from what I understood in the law, what the public sees, or what the natural person sees, meaning non-business, personnel. So what the natural person sees, that's the thing that we need to be careful of. And guess what? If I work with another company and that company is going to present it to the public, I need to be responsible for adding the AI markup and deliver it like that to the company. If, for example, that other company doesn't have any plans of showing that image to the general public at all, right? I still have to mark it. And the reason is, in that company where I'm going to deliver my work, there might be some natural persons working there, and they might look at that image and then they might be deceived. So therefore, everyone has to mark everything. But then there was this other thing that I also kind of was curious about. If you, for example, now this is my interpretation of things now, since the only thing that kind of counts is pretty much the the deceiving part of the viewer, because this whole law on AI is pretty much about deception and speed of work. It's pretty much what it's all about, right? So if the image that you created has a little bit of touch-ups of AI here and there, that's not a problem, right? If it has major design changes, that's a problem. So we are generally talking, okay, so I'm going to have this little bit of part here being manipulated with AI, then a little bit of this, then a little bit of that. But let's take, for example, Magnific. So Magnific is a website that enhances your render to look photoreal. The image visually stays the same, but it just looks real. Now, that whole image is processed through AI. Like every single pixel is AI generated. Now the question is, do you then need to mark it? Because it's not like you fixed a bit here and a bit there, it's everything. Well, what matters is the complete visual kind of impression, right? So if visually you can prove that, when you render that image on your computer, that it looks, I don't know, 90 or something percent the same as this image, then you're not subjected to put the AI label on things. So I don't know how many of you remember, but I made this video on how I use AI without using AI. And the idea is pretty much this, where I imported, my raw render, I enhanced it with AI, and then I replicated the entire thing from AI directly into Max. So I generally was curious, if I generate an AI image, but then if I replicate the whole thing in Max, meaning I used my own know-how or my artistic skill to do that, is it then considered an AI image? And apparently the EU says no, because there is this one big thing which EU has a super big value for, and that is the actual artistic skill. So the problem is, European Union has a problem with abnormally big speed that human cannot match. That's the problem with AI that the European Union has. On the other hand, it has a problem with deception, meaning that you can create things that are not real to look completely believable and completely real. And those are the things that need to be marked as AI. They're pretty much just a pointer. Somebody was, I don't know, cheating or whatever. But here is the thing. Deception. The whole kind of EU law constantly says, so look at this, deployers who use AI system. By the way, deployer is a person who uses AI. So deployers who use an AI system to generate and manipulate image, audio, or video content that appreciably resembles existing persons, objects, places, entities, or events, and would falsely appear to a person to be authentic and truthful, should be cleverly and distinguishably disclosed that the content has been artificially created. So we are making renders, right? I've been making renders for the past 25 or 26 years. And the only thing that I'm doing my whole entire life is trying to create that render to look as real as possible so that I can deceive. Is that it? So what is pretty much happening? EU doesn't like AI that much because it deceives people. But if I use my art and skill to deceive, deceive sounds like a criminal thing to do, but you know what I mean, because here they're pretty much, saying deceiving of places. So that means like if I make a render or an AI image of a building that's about to be built, I am deceiving the viewer so that he might think that that building already exists, right? So let's just put that. So how is my kind of, artistic skill that I have crafted for 20 plus years, like how come that is okay, but when AI does it, it's not okay? So look at this part. I'm saying to Notebook LM here. It's funny because AI will be marked as, watch out, this might be dangerous or deceiving, but then me, a CGI artist, crafting my skill of deception with my 3D images, I'm fine. And get this, it's an ironic distinction. The law focuses on the automated scale of deception rather than the artistic skill. The EU rationale is that while you spend days or weeks on a single render, AI can flood the internet with synthetic content almost instantly, creating systemic risks for mass disinformation. Because your work is a human intellectual creation, it carries the weight of your editorial responsibility, which the law treats as built-in safeguard. Essentially, the watch out label is response to the speed of the machine, not a judgment on your talent for realism. So in general, EU pretty much has a problem of the major problem with speed of things. And that's why it's labeling everything, risky or sketchy or dangerous, just because it knows that, that speed can just spread in minutes to tens of thousands of places. Okay, but let's talk about the whole vibe coding thing now. So writing scripts with AI and all that. Well, apparently that's not an issue. It's not an issue if you write a script and then use it on your project, as long as the majority of whatever you're seeing on the image is your own creation. Script is just an assistive tool. But what if you decide to sell the script that you made with AI or a plugin that you made with AI? Well, apparently you need to mark or label scripts or plugins that they are AI if the majority of that script or plugin was made with AI. Again, assistive AI is a thing here. So if you wrote the majority of the code, but have the AI, fix a few bugs here and there, that's not a problem. But if you made the entire thing with it, you have to pretty much label it as AI in a machine readable format. So there's this part of the law which says transparency obligations for providers and deployers of certain AI systems. So providers of AI systems, including general purpose AI systems generating synthetic audio, image, video, or text content, shall ensure that the outputs of the AI systems are marked in machine readable format and detectable as artificially generated or manipulated. So at this point, I pretty much, wanted to ask, like, what does that mean? Like, when you open a plugin, it says made with AI, or do you just, like, on the web page where you download the program, has to say there that it's, made with AI or something? Well, apparently not. You have to fill the metadata in the whole, like, code, that it is AI, generated or AI altered or whatever. So yeah, even scripts and plugins are going to have the label. Now, I'm talking about all these restrictions here, but, what are the actual fines? Like, how does that work? We got to the part which says penalties. So pretty much, if you disobey these rules, there are various penalties that can, come your way. The maximum penalty that can happen is 15 million euros or 3% of a total worldwide annual turnover, which, like, whichever is higher. So, for example, with me in Croatia, for the type of business that I have, for example, the penalty is, so by the way, for all of you from Croatia, obrt, I have obrt. So for my business model that I have, the penalties can go from, I think, 2.5 to 13,500 euros, right? For like legit full-blown companies, it goes up to 135,000 euros. But on an EU scope, it can go to 15 million or, 3% thing, meaning whichever is higher. So penalties are no joke. At that point, I was, thinking like, okay, but, how does that thing work? Like, does somebody just need to report you and then, somebody checks on you and then you get a fine? The law says this. Look, it says the AI office. So it's an AI office. That's a thing. So AI office should be able to carry out all necessary actions to monitor the effective implementation of this regulation as regards general purpose AI models. It should be able to investigate possible infringement of the rules on providers of general purpose AI models, both on its own initiative, following the results of its own monitoring activities. So, I was kind of thinking that, somebody has to report you for that, but apparently, they're going to have monitoring activities to see who's right, who's wrong. But the general thing for this whole kind of stuff is, even if somebody, accuses you that you used AI on something, right? If you prove that you did not use, that it's your own work, that the majority of the stuff that's being seen is your actual genuine creation, then, nothing happens and we're all, cool. There's generally a lot of things to talk about here. Like there's also a part on how you should embed like machine readable marking on your website that doesn't allow AI companies to scrape your content. So it's tons of stuff. So yeah, it's an interesting read. By the way, you can download, like I said, all these laws on the EUR-Lex website. I'm going to leave all these PDFs in the description in the form of the link. So if you want, you can throw them into, NotebookLM or whatever and see what's up there. But if you really want to know where I'm currently at with AI, I highly suggest that you head over to my Patreon, but because here you have the where I'm currently at with AI video, where I generally explain what I currently use, how I currently use it, and how it's benefiting me, and how I'm optimizing my whole workflows with everything. And yeah, this is generally it. There's going to be probably a lot of discussion and a lot of debate on AI for, on the law here. Again, I'm not a lawyer. I like this was just my interpretation of things. Do your own research. But yeah, something is boiling in the EU Union. See how it affects you. Just one fun fact for Croatia, for example, on top of this law, we actually, less than a month ago, there's a law in Croatia which pretty much says anything, any output, right? Anything that the viewer sees, any output touched with AI has to be marked as AI. European Union has that thing that, you can fix a few things here and there and you're good. But Croatia, for example, it says any sort of touch up with AI, you have to label it as an AI. So yeah, fun time await us. I believe a lot of these things will change. But until then, see you in the next video. Bye.